Good morning. My name is Hae-Sung Kim, advisor of Gangnam Labor Law Firm. Today we will discuss about a particular article case that was published by a Labor Daily. So the title is the strike workers' recovery of wages by the CJ jail company. So could you explain about the particular case and the background story, please?
Okay. Hello, how are you today? This is Bong Soo Jung, Korean Labor Attorney. Thank you for asking. This is regarding some unfair labor practice conducted by the CJ Jaeiljedang, one of the biggest companies located in the North Chungcheong province. So they conducted some unfair labor practice by retrieving the wage they paid to the workers, but only they discover they get back withdraw what they pay, but from strike workers, not the normal workers. So it became unfair labor practice. Unfair labor practice means employee hate labor union and their strike workers, and they treat them unfairly or disadvantageously. So this is a violation of workers' right. Workers' right means right to organize a labor union, right to negotiate with the employer, and right to take collective action. These are three rights of labor. So if employer some hate union members or union and try to give a disadvantage to strike workers or union, then it is regarded as unfair labor practice. Yeah.
I see. So historically in Korea, unlike other employer and employees cases, conglomerate like chaebols, like Samsung or CJ, has not had this kind of dispute between the employer and employee. And this case can be giving a good lesson to the chaebols about not meeting the regular labor law, labor law. So do you think this case can give a lesson to the chaebols in the future?
Yes. Unfair labor practice, this means employer violate severe the Labor Union Act. It is originated from Constitution. Korea government or Korean the government system has been established by the Korean Constitution. So one of the articles, Article 33 of the Constitution, stipulates solid right of workers and labor unions. So based on that, Labor Union Act was established, stipulated in the actual subsidy law. So employees should follow this law because this is workers' legal right protected by the Constitution. So if employer do not follow, do not observe this law, that is a violation of Constitution. Yeah. So I think this CJ Jaeiljedang should be punished. Also, they must give up their this kind of policy, the hate union, and do not accept their proposal for collective agreement. So I think this unfair labor practice should be corrected. Yeah.
So it means that the workers who were on strike was treated with disadvantage from CJ compared to the ordinary workers who didn't go on strike. Is it right?
Yeah. So what is unfair labor practice means employer try to give a different treatment to those workers who do not belong to union membership. So only they discriminate union members or strike workers. So that is they try to give some unfair or disadvantage treatment to those who participate in labor strike. So something this is we call it unfair labor practice. So in order to protect the social right of labor, labor inspectors must be involved in this protecting union and their workers. Then the union can survive in the workplace. Without the support from this the Labor Union Act, union cannot survive. So employers should be punished for their unfair labor practice or not. How union can survive? Also, they can continue to negotiate with the employer. So I'm very much sure the CJ 제일제당 must correct their the policy to the neglect union or do not respect union as their the bargaining partner in the decision, maybe in making some the working conditions.
Yes. So I understand that Samsung chairman Lee Jae-yong also announced that he will respect the labor union in future. So Samsung will need to respect the labor union like other employers. So this case can be a good lesson. Do you agree?
Yes. CJ 제일제당 is some relative company to Samsung Group or Samsung Electronic Company. So they have the same the policy to avoid having the union. So it is a severe violation of Korean labor law. So without respecting Korean labor law, they cannot continue their business in Korea. So they must know. So also they think they are employers, so they cannot do everything. But according to Labor Standards Act, so working conditions should be decided by mutual agreement on equal footing. So labor union represent workers in the course of making such working conditions. So they must respect what the law provides.
Thank you very much for your comment.
Okay, thank you for watching. Bye bye.